Welcome to this podcast. I'm Gordon McElroy. I'm a director in MKB Law. I have with me Chris Mason, who's the head of our litigation team. And Chris is going to explain how alternative dispute resolution and mediation work. Morning, Chris.
Hi, Gordon. Good to be talking to you about mediation. Obviously, it's an important topic that maybe people don't know enough about.
And is it fair to say, Chris, you trained in England, that mediation has for some time been much more prevalent in England than we tend to see it in Northern Ireland?
I think that's probably right, but that could just be because there's far more cases of any type and nature going on. Bigger jurisdiction. Yes, but it's I think since the cost reforms in England, it's become perhaps people are more encouraged to mediate, and it sounds counterintuitive, but where there's an opportunity for a person with much deeper pockets to take advantage, if I can put it that way, over their opponent, because they can actually afford to fund litigation longer than they think their opponent can do.
In poker terms, to buy the pot?
Yeah, absolutely. That could be seen as a way of not resolving the dispute, but keeping it going to an ultimate victory because the other party runs out of money.
Well, let's just take a step back. You and I are involved in litigation, and we decide, or we're told by the courts, that we should mediate. Explain the format of that to me.
Yeah.
What could I expect if I'm told that I need to be involved in a mediation process?
So we would arrange a date, and we would all turn up to the same place, plaintiff and defendant, legal teams, and there would be an independent person who is the mediator. And the mediator is usually almost exclusively a qualified lawyer, perhaps an ex-barrister or practicing barrister, solicitor, or even an ex-judge. And that person's role is to hear what each party has to say about the dispute, and then to privately discuss with each side what might be the strengths and weaknesses of their own case, of their opponent's case, and perhaps try and get the parties to see sense on points that they might just be blinded about.
And can the mediator take a decision about what should happen in the litigation?
No, it's not the mediator's role to make decisions. Everything that's discussed at mediation is without prejudice, so it can't be repeated in court.
If one party makes a big concession or reveals some fact in the mediation, are you saying I can't use that?
The whole purpose of the meeting of the mediation is to have a full and frank discussion about the issues and see if there's any way of narrowing those and ultimately settling the dispute. So in order to be full and frank but not completely give your hand away, you have to have that protection of without prejudice privilege.
And is everything that's said in the mediation confidential? Can any of it leak out anywhere?
Theoretically, it's all confidential. I mean, we can never legislate for people leaking things. But yes, effectively, a mediation is like Chatham House. It's whatever's said in there is not supposed to go any further.
So if I'm involved in a mediation, Chris, are there any rules that govern the way in which the mediation is conducted?
So whenever you have a mediation, the parties would sign up to a mediation agreement. There's various bodies that would have their own terms and conditions for mediations. They're all broadly similar, but effectively it's a contract between the parties to engage in the mediation on terms as set out in the contract.
If our mediation is successful, then are we restricted to just whatever a court could order by way of a resolution of a case, or can we step outside those proceedings and potentially do more, come to separate agreements?
Ultimately, yes. I mean, you would be guided by the remedies sought in a court as to what the settlement would be, but as long as it's not illegal, you can agree anything for the resolution of a dispute. There may be a main strand running through the dispute, but there's ancillary things consequential of that, which you might not be dealing with in the court proceedings, but you could take the initiative to actually tie those things off at the same time.
I'm sure you're very familiar with the clients who are having a fight over something which is actually a proxy for a different row.
Yes.
And so are you saying that mediation can result in being able to deal with the bigger picture as well as just the proxy battle?
Yes. I mean, you deal with the substance of the dispute, and if there are other issues arising that are connected or even not connected, that relate to the same parties, you can attempt to resolve all of that in one go.
And let's say we shake hands at the end of it. How do we enforce whatever agreement there is?
So we would draft a settlement agreement, which is effectively another contract. If we had court proceedings issued and they were ongoing, we would draft an order that we would ask the court to grant, which would be effectively bringing an end to the proceedings, dealing with whatever had been agreed about costs, and then there would be a schedule to that, which would effectively be a settlement agreement, a separate contract setting out what the dispute was about, what has been agreed, and other terms to protect each side, such as confidentiality, agreements not to sue, things like that. Yeah. If we didn't have court proceedings, you would just have the settlement agreement.
Okay. And you mentioned costs. Is mediation an expensive procedure?
In the grand scheme of litigation, it's not expensive.
Litigation's not cheap?
Litigation is not cheap. So I think it's cost effective. If you look at mediation as the cost of a one-day event to try and settle a dispute, at first blush, it could seem expensive. But actually, if you view it through the lens of that day may put an end to the next 18 months of litigation, it's actually extremely good value for money.
Not often you hear a lawyer say good value for money. And let's say the court has said to me, you should mediate, and I say, no, I'm absolutely refusing to mediate. Could that have any impact on what happens to the costs of the proceedings at the end of the day? If I run the whole way through and I spend £500,000 on taking somebody to court, is there an impact?
Yes, absolutely. And it's as a lawyer, it's a really difficult position to be put in, because you want to extol the virtues of mediation anyway, but if a court has reinforced that they expect a mediation and your client simply doesn't want to engage, there's some very difficult advice that has to follow, which is, for example, if we don't take the opportunity to mediate, which could have resolved the dispute, and we then go into a trial, and the trial is a week or 2 weeks long, you could be looking at anywhere between £50,000 and £100,000 on each side for the costs of that trial, and
more,
or even more. Obviously depends on the nature of it. If you get to the end of that process and you have been successful or unsuccessful, but the judge is then being addressed on cost issues which really don't arise until the end, and the judge is informed that a very strong invitation to mediate was ignored and that the costs of a trial could have been avoided, depending on the outcome, you could end up having to fund not only your own legal costs of the proceedings, but certainly your opponent's legal costs of the trial or to a defined point leading up to the trial. So
that's bound to focus minds if you're being recommended to mediate at an early stage.
It should, and most often that advice is taken, but there are times when it isn't, and it's.
So to round off, in your view, would it be fair to say mediation's a proactive thing which should be looked on positively when parties are trying to resolve disputes?
Absolutely. It is a proactive step. It's a sign that both sides are genuinely trying to resolve the dispute. And why anybody wouldn't want to swiftly and cost effectively resolve a dispute is beyond me, but there are times when it happens. But anybody asking my advice on mediation would receive positive reinforcement of taking that step.
Yeah, makes sense to me.
Absolutely.
Thanks, Chris. That was great.
Thanks, Gordon.